Welcome, everyone. We'd like to thank the American Society of International Law for hosting us again. This program is put on by the Liber Society of the American Society of International Law, and this is our eighth in a series with experts on current topics in international humanitarian law. The series began in October 2023, and we've had regular meetings with a number of these experts you see before you, as well as new people, since then. The program is also co-sponsored by the DC Bar International Law Community, and we'd like to thank them for their support. These discussions with experts in IHL allow us to discuss established principles of international humanitarian law, focusing on the basics of IHL, such as military necessity, proportionality, the role of the Geneva Conventions, as well as addressing IHL in a rapidly changing technological environment. This panel addresses current topics in IHL, including protections for civilians, targeted killings, the roles of the ICJ and the ICC, and the application of principles of IHL to drones and autonomous weapons more generally. I want to draw everyone's attention, and whatever the panelists choose to talk about. I want to draw everyone's attention to the issuance since our last webinar on October 17th of a new commentary on the Fourth Geneva Convention by the International Committee of the Red Cross. Pranav Agarwal, who is kindly assisting us, recent graduate of SFS of Georgetown and an IHL instructor for the American Red Cross, will post that in the Q&A. And the Jackson Center is launching this Friday a year-long symposium with monthly events on Nuremberg. And he will also post that information in the chat. I'd like to introduce our speakers today, some very familiar to you. Professor Shiri Krebs will speak first, Professor of Law at Deakin University, Director of the Center for Laws Protection, and a visiting legal fellow of the Australian Government Office of Foreign Affairs and Trade. I hope I got that correct. And Omar Shakir is the Israel-Palestine Director of Human Rights Watch and an adjunct fellow at Georgetown University in Qatar. Cody Corliss is an associate professor at West Virginia University College of Law and worked at the Office of the Prosecutor for Criminal Tribunals at The Hague and at the ICTFY. Professor Leila Sadat is the James Carr Professor of International Criminal Law at the Washington University College of Law and served for many years as Special Advisor on Crimes Against Humanity at the ICC, and has recently been appointed as a U.S. expert to the OSCE Moscow mechanism. So welcome, everybody. We're going to begin with Professor Krebs. Shiri.
Thank you very much. Good morning here from Nara, Melbourne. And before I begin, I would like to acknowledge that I'm joining you today from the unceded lands of the Wurundjeri people of the Kulin Nations, and I pay my respects to elders past and present. So I thought I kept changing what I was planning to open with as sadly reality unfolds. So I think I'll begin with the number 98, which is the number of Palestinians who died or killed in Israeli incarceration facilities since October 7. Many of these people, even according to the Israeli authorities, were not Hamas operatives or fighters in any way. And these numbers released recently are a continuation of a story that has been unfolding since October 7, with recent revelations in the last couple of months on severe inhumane torture that has been happening in Israeli detention facilities. And even though throughout the years since October 7, 2023, there's been a kind of a call to release the Israeli hostages held by Hamas, completely justified, of course, call to release the hostages. most of the discussion of Palestinians held by Israeli authorities um, related to these people as prisoners or detainees, as if there was some sort of a legal process that justified these detentions. But sadly, those dead and those still alive, thousands of people still held in Israeli detention facilities, have not been detained through any sort of legal process. They have not, their detention has not been reviewed by any legal officer. Many of them have not been um, you know, even charged, so not charged in a legal sense, but there are no evidence even for some sort of security or preventive detention. So the situation is that Israel holds as hostages thousands of people that the calls for their release, sadly, are not strong enough around throughout the international community. And I would like to take the opportunity this morning to call for the release of all Palestinian hostages held by Israeli authorities, um, and going through severe types of tortures in Israeli facilities. One of the most depressing things I thought was that in Israel, it seems to have been in the last couple of weeks um, that the main concern has been how some investigation materials were leaked to the media by the military prosecutor, rather than the actual facts that were leaked, which are horrible evidence of rape and torture of detainees. The 98 people who died in Israeli detention facilities died from either violence or starvation or deterioration or neglect, not receiving any medical care. So I think in my mind, this is one of the most important things we should pursue as international lawyers, is to call for the release of the Palestinian hostages. Of course, they also did not receive any visitations from the Red Cross, and that is something that must happen immediately. So, and I remember Omar and I were here on October, I think 27 or 29, 2023, on the first iteration of this series. And I think both Omar and I remember, opened our respective talks or remarks by calling for the release of all hostages. And I really want to reiterate this now, years into this violence, that I call again for the release of all hostages. Um, so the other thing that I wanted to note in the kind of the last 2 minutes of my opening remark is the ceasefire in Gaza. And of course, we all know hundreds of Gazans were killed by um, Israeli violence since the ceasefire. And I wanted to say something about the justification for this given by Israeli authorities to this continuous violence. And in many of these cases of continuous violence, despite of the ceasefire, reports were that Gazan people returning to their, or attempting to return to their homes, crossed the invisible yellow line. Um, that yellow line supposedly should kind of maintain some sort of Israeli security area where Palestinians should not cross. But of course, this invisible legal ceasefire line is not something that people on the ground, especially within the terrible conditions currently in Gaza, can maintain or even or even know about. A lot of the violence in Gaza has been kind of, following some sort of warnings that some area or another, should not be inhabited, or that people in a particular area should evacuate elsewhere. And that sort of use of legal jargon to move population away from their homes um, is a part of the atrocities of war, keeping people away from the few places where they can still find shelter, keeping people away from the few places that are still standing, or from looking at their remains of their home, trying to locate some of their belongings. Um, I find this situation horrendous beyond words, and I call again to respect the ceasefire in its substantive meaning, which is to not kill civilians anywhere on any side of any invisible ceasefire line, um, because these are people. And given that in the at least several incidents since the ceasefire where civilians were killed by drone fire, they were not threatening anyone, they were not holding weapons, they simply crossed this invisible ceasefire line. So I think we really should start thinking about international humanitarian law not as a technical vehicle to maintain, imaginary lines, but as a substantive humanitarian body of law that is intended to protect civilians during armed conflict. And the main principle would have told us that firing or using drones to kill civilians, unarmed civilians, during a ceasefire is wrong, whether they crossed an invisible line or not. So I'll end here, and I'm happy to touch on any of the other subjects during the Q&A. Thank you.
Thank you very much, Shiri. And let me invite anyone in the audience as we go forward with Omar Shakir next to put any questions you have in the Q&A, and we'll field them as they come in after the panelists have finished their intros. Omar.
Thank you. And Shiri's words are really powerful, and I kind of want to pick up where she left off, which was just take stock of the moment we're at in Israel-Palestine in light of international law, and cover some of the recent developments. And I share much of Shiri's view. The ceasefire brought relief. It brought relief for the families of hostages to finally welcome their loved ones at home. It brought relief for those that were able to bury their dead, whether they were Israeli hostages or Palestinians who were killed and returned to Gaza. It brought relief for the Palestinian detainees. There were nearly 2,000 that were released, the vast majority that were held without trial or charge. They were from Gaza. And it also brought relief to some degree for Palestinians in Gaza. But this is really no time to exhale. I think Shiri covered some of the developments, but just on a factual level, what we're seeing 1 month since the ceasefire has come into effect, trucks of aid and food into Gaza are nowhere near what was set out in the agreement. We're talking about 150, 200 trucks a day as opposed to the 600 that was committed to. Basic services like water and electricity, healthcare have improved, but not yet at the levels needed given more than 2 years of the use of starvation as a weapon of war, sweeping restrictions, deliberate attacks on these facilities that we and other groups documented. Attacks have continued. There have been more than 250 Palestinians killed, according to Gaza's health ministry. In addition, and Shiri covered this, so I won't repeat it, these Israeli forces remain in control of about 52% of Gaza, and they're continuing to carry out demolitions. Demolitions in occupied territory are only justified when there's military necessity. These areas have been nearly fully ethnically cleansed, and they've been razed. So the idea of military necessity there simply doesn't meet any test of international legal principles. In addition to everything I just said, it's worth noting we aren't talking about the West Bank. Human Rights Watch on Thursday will be releasing a massive new report documenting some developments there. I won't get ahead of our release, but I will note that we've seen the largest displacement of Palestinians from refugee camps in the West Bank since 1967. 32,000 people that have been displaced, and they've been blocked from returning to their homes since the Israeli military operations began there in January and February. And we continue to see an alarming increase in settler violence, which is in effect state-sanctioned violence because there is widespread impunity for those abuses. And as we've documented, they often take place with Israeli soldiers looking on or even participating. And we're not talking about accountability for the crimes committed over the last 2+ years, much less root causes. And so, as a legal matter, it's important to underscore that the obligations to restore aid, to not block aid, to ensure they enter, to release those unlawfully detained, they apply ceasefire, peace deal or not. That's irrespective to the legal obligations, either of Israel or of Palestinian armed groups. I also want to reiterate that Israel remains the occupying power in all of Gaza by virtue of its effective control. This is a position that's been spelled out over many years. I know in previous sessions, we've had an exchange on this point, but this is really the consensus point of the Red Cross, of the UN, of member states. So it's not just the 52% where Israeli forces are, fully in control and have cleansed much of the population, but even in the remainder of Gaza where they continue to, control what comes in or out, even the UN aid, it's going on a circuitous route because of Israeli permissions and where they come or don't come, access to the sea. So Israel continues to have all the obligations of an occupying power under international humanitarian law. It's also worth noting that even the minimal agreements that are in the U.S. comprehensive plan to end the Gaza conflict, Israel isn't adhering to them. Beyond the aid, Rafah, the crossing between Israel and Egypt, was due to be reopened. It hasn't reopened. The U.S. plan talks about Palestinians from Gaza. There are more than 100,000 Palestinians from Gaza that fled, mostly during the first 9 months of the hostilities when Rafah was opened, before Israel seized control of it. Many of them want to return home. We're speaking to them, even if home is a pile of rubble. But Rafah remains closed despite the agreements there. I mentioned the West Bank. Refugees. Yesterday, the UN Security Council passed a resolution to, in essence, enshrine the U.S. comprehensive plan there. I think it's telling that the document does not mention the word human rights in there. But regardless of whether or not it's in there, of course, international law applies to all that comes in the time ahead. Whether or not the resolution mentions the right to self-determination, the right to self-determination remains an important legal principle. So I think it's really important to underscore those things and also to learn from history. History shows us that sometimes the Oslo Accords are a great example, that interim arrangements sometimes become permanent. Areas A, B, and C, which are supposed to be transitional, agreed upon in the 1990s, or not even late 1990s. Here we are, 2025, and they're still very much in place. This yellow line risks becoming permanent, and we're not seeing much movement, of course, towards full withdrawal. So there's a real risk, of international action, if people exhaling and turning their attention away. We continue to believe that under the Genocide Convention, signatories have a duty to take action to prevent and punish genocide. And again, that obligation isn't triggered by a definitive determination of genocide, which we know won't come from the ICJ for probably years. That is triggered by the mere risk of genocide, which the ICJ provisional measures of January 2024 should have been the clear trigger there. Those remain valid. Israel is in flagrant violation of that. I will again note, since we last spoke, the ICJ issued a new advisory opinion regarding the obligations Israel has towards the United Nations. That is a very important advisory opinion. I encourage everybody to read it. In large part, it underscores that Israel is required to ensure the unhindered provision of aid. That it also dismissed Israel's allegations against UNRWA as unfounded and suggested that its that Israel's obstruction of UNRWA's work is inconsistent with international law. That followed a request from the General Assembly. And of course, as we speak, Israel has The Knesset last year passed laws restricting UNRWA's ability to operate on the ground, and the Israeli government has taken steps. Schools that UNRWA operates in occupied East Jerusalem, several of them have not been able to open. UNRWA itself has not been able to directly deliver aid into Gaza, and so these are all inconsistent with Israel's obligations. Again, those apply regardless of whether the Trump plan or the Security Council resolution mention them or not. A lot more to say, but I think I'll leave it more or less there and just sort of again underscore that regardless of whether or not we have an agreement, states should be taking urgent action. And what we've called for is the imposition of targeted sanctions on Israeli officials responsible for serious abuses, the execution of all ICC arrest warrants, as well as the suspension of preferential trade agreements with Israel and the in these sort of measures in order to meet the duties under the Genocide Convention, other articles of international law. So I'll stop there and look forward to the discussion.
Thank you very much, Omar. Cody.
Thank you, Marianne, and thank you, Omar and Shiri, for raising some really, really valuable and important points. So I'm going to shift gears a little bit, and the theme today is international humanitarian law in crisis. And we've seen how that's played out, where parties are not respecting international humanitarian law, parties are contorting their interpretation of IHL to suit their means, parties acting with impunity for IHL abuses. So I want to start by actually focusing on, I think, something interesting and something maybe a little more positive. And that is we've seen an increase number of voluntary reports by nations on their IHL compliance. It's important to note that the Geneva Conventions and the additional protocols don't provide a mechanism for how parties should meet or report on their compliance with their compliance obligations, their IHL compliance obligations. And a roadmap for better national implementation of IHL was adopted in 2019 with the 33rd International Conference of the Red Cross and the Red Crescent. And so in 2019, we see this implementation, this conference and this resolution. And since then, we've seen various countries offer voluntary reports showing their IHL compliance at the national level. And what's to me most interesting is the Ukraine at the end of 2024 filed its Ministry of Defense, filed its own voluntary report on its implementation of IHL. And so it's certainly not the first voluntary report, but it is significant in that Ukraine is engaged in an international armed conflict. This report comes at a time following Russia's full-scale invasion in 2022. And so the report is valuable in that we see Ukraine offering its understanding of its IHL obligations and its responsibilities, and also noting the importance of protection of civilians and protection of civilian objects, and also noting the lawfulness and limitations regarding the use of certain weapons. And it's valuable in the sense that this report demonstrates Ukraine's commitment to IHL and international law more broadly, and we've seen that throughout the conflict. So this is, in a sense, another reaffirmation by Ukraine that international law matters. And Ukraine's voluntary report is, I think, a significant contrast to Russia, which has waged a war of aggression and often seemed to violate IHL or has seemed to offer maybe a contorted interpretation of IHL to justify its actions. And in one sense, I think if we think about Russia's questionable interpretations on IHL, questionable interpretations of IHL to justify its actions, that also suggests to me that Russia realizes that IHL does matter. Because if it didn't matter, they wouldn't try to justify their acts through the IHL lens. But also, Ukraine's voluntary report offers, I think, a public countermeasure to Russia's allegations that Ukraine is violating international humanitarian law. Russia's made these arguments both in its ministry reports and statements by its leaders, but also in statements and filings at the ICJ. In fact, though, we've seen that Russia has engaged in attacks on civilians and civilian objects. We've seen that in Bucha. We've seen that at the Kramatorsk train station that killed over 50 Ukrainians, and where Russia's representative at the ICJ claimed that the attack was orchestrated by Ukraine, specifically in order to scare Ukrainian civilians so that they would remain in the country, which seems to suggest that Ukraine was committing a crime of terror. And we've also seen this in the widespread use of first-person view drones, which are drones that can be operated a bit removed from the conflict zone to specifically target and menace civilians in Ukraine. And with this, we've seen obviously the arrest warrants at the ICC, the most notable, of course, for the violations of IHL. The most notable are the arrest warrant of Vladimir Putin and his commissioner for child rights, Maria Lvova-Belova, rather. And we've seen that in four other arrest warrants involving the what are considered to be disproportionate attacks against the electric power supply. So strikes against electric power plants. And moreover, though, it's important to note, I noted how that Ukraine has filed its voluntary reports, and Ukraine is also engaged. We talk about the ICC, but it's important to note that the bulk of prosecution for IHL violations often occurs at the domestic level. And Ukraine has a really robust legal system, and it's identified a number of crimes that have been committed, violations of IHL in Ukraine. They've indicted over 500 individuals. They've reached a number of verdicts. And at least one thing that's interesting or unique about Ukraine is they do allow in absentia trials, but at least approximately 20 of those have been in-person convictions of Russians who have been captured, who are enemy combatants. So that's one thing to think about, that many of these violations, the prosecutions for these violations, we often talk about the ICC, but at the end of the day, many of this work will be done in Ukraine at the domestic level. Thank you.
Thank you very much, Cody. And I just want to note that the advisory opinion Omar referenced earlier that all three of the panelists have spoken of is now available in the chat function, should be, and we can put it in the Q&A as well. Leila, sorry, please go ahead.
Oh gosh, no need to apologize. I'm really delighted to join friends and colleagues, new and longstanding. Like Shiri, I really struggled with what to say during this webinar, because here we are 2 years after the October 7th attacks, debating the laws of war and their applicability. And so I've sort of subtitled my remarks "Barbarians at the Gates," because I think there's plenty of bad news to go around. Cody, I was delighted to hear there might be some good news, because I think we really need it. I'm going to do what I often do, which is try to go back to a little bit first principles, kind of step back, and then we can dive into some of the details, because I think Cody, Shiri, and Omar have given us some really great, very detailed points. And what I'd like to do is turn to the Chief Legal Officer of the ICRC, Cordula Droje, who wrote sort of a cri de coeur, an appeal to humanity in the pages of Just Security last year. And her point was that under the laws of armed conflict, we acknowledge that both sides will inevitably kill, they will injure, they will detain, and they will destroy. But the purpose of IHL, or the laws of our conflict, is to prohibit us from dehumanizing our adversaries. And turning this apparent contradiction into binding rules is the work of the Geneva Conventions and a multitude of other treaties and norms, including the Hague Convention of 1907. 7 and the 2 additional protocols to Geneva, there's a vast set of rules that is supposed to govern war. It governs everything from choices of weapons, detention, interrogation, prosecution and punishment, caring for the wounded and sick, and the treatment of populations under a party's control, which you've heard about a couple times already today. And IHL, as we like to call it, international humanitarian law, sets an outer limit of acceptable behavior, a boundary that we draw for the simple reason that stepping over it effaces our own humanity and brings shame to ourselves and our states because of the harm that we're gratuitously inflicting upon our adversaries. This goes all the way back to Henri Dunant and the Battle of Solferino, where he saw the suffering of soldiers in the field and said, this does honor to no one. We've always had challenges of noncompliance. We've always had challenges of impunity. We have limited jurisdiction of national and international courts. We have procedural and substantive barriers, including immunities. And we have the actions of individual leaders who don't see the laws of war as a necessary shield for their own soldiers, for example, and their own civilian populations, but they see them always as an unnecessary constraint. But I think what's been happening and why I'm a little depressed, and I'm glad Cody cheered me up a little bit, but right now we see many leaders, including leaders of so-called democratic nations, using the concept of war as a talisman to destroy normal legal regimes that should apply in peacetime, including human rights law as well as IHL. I mean, this isn't new in a way. The preemptive war doctrine of the 2002 national strategy of the Bush administration, which resulted in the invasion of Iraq, was there. The regime of creating law-free zones in which individuals labeled terrorists could be sent and tormented, unprotected by either IHL or international human rights law, and that's how we got Guantanamo Bay. And the idea that we need new rules to fight new enemies, while at the same time employing scary new technologies like AI that make killing faster, more devastating, and less decent, have resulted in civilian death tolls and property and environmental damage far outstripping prior conflicts. Starvation, which we thought should have disappeared as a method of war, has returned as a weapon of war in Gaza, in Sudan. The bombing of hospitals, the killing of humanitarian workers and medical personnel looks like something out of the dystopian science fiction films like The Hunger Games. And women and children are being killed in staggering numbers. Last summer, it was reported that nearly 1 million Russian soldiers had been killed or injured in the war started by Vladimir Putin against Ukraine, with Ukraine reporting equally horrific casualty levels in this war of attrition. And again, to quote Cordelia Droji, when we look at the rubble of Raqqa, of Aleppo, of Mariupol, of Gaza, or the inhumane prison conditions in which people are held, it's just not good enough. We are not doing well as a global society. Victims don't need lip service to IHL. They need a culture of compliance. And we have heard this even from, I could quote William Taft IV, who was the former legal advisor in the Reagan administration, who commented about the DOJ lawyers who penned memos supporting Guantanamo and torture, that they had a hostility to international law, and that it's a mistake to disconnect an organization like the U.S. Army from a system of rules under which it's been operating for many, many years. Right now, we're seeing states like the United States, and sorry with my depressing analysis here, but blow completely through the laws of war in the deathly strikes on the boats in the Caribbean. They're arguing they comply with international law, which I think is an implausible thesis. And so if you have countries like the United States and Israel articulating doctrines that simply are non-compliant with IHL, I don't think we should be surprised that regions like the Eastern Democratic Republic of the Congo are now in an escalating humanitarian and health crisis, with more than 11,000 cases of sexual violence reported since February 2025. right? The same with the conflict in Tigray, which was marked by gratuitous and horrific levels of sexual violence, as well as other atrocities. So what do? I'm going to try to channel my inner Cody here and get a little bit more positive. We need more, not less, training in IHL. The fire of top military commanders and JAG officers in the United States has been deeply alarming. The same with the shaming and the attacks on the IDF officer who leaked what had happened in detention. Individuals that report on atrocities should be held up in high esteem, not fired and not treated poorly. These are the individuals equipped with the practical experience of the laws of armed conflict and the legal knowledge of IHL, and they're uniquely able to give good advice to both civilian and military commanders about what is not permissible and what is. The second thing is we need more accountability to combat impunity. I agree with Cody. National systems can do a lot of the work for us in places like Ukraine, but in places like the DRC, I don't really think we're seeing a huge national response. So we need international prosecutions, and yes, we need universal jurisdiction, which is expressly included in the Geneva Conventions for grave breaches. We've seen some great universal jurisdiction prosecutions in Germany and other places in Europe relating to the conflict in Syria, as well as the conflict with, relating to ISIS attacks on the Yazidi, but we need more of that. And it's not just IHL that we need to enforce, it's also the prohibition on the crime of aggression and the two related core crimes of genocide and crimes against humanity that fill gaps in the law of war. And I'll come to my conclusion in a minute. We also need to stop glorifying violence and tell politicians we don't want it. We need to raise the political cost of conflict in places like Ukraine, where Russia has invaded Ukraine. The cost to Putin's regime has been extensive, but that cost needs to continue in order to provide incentives for the conflict to stop. And one of the things that we've done that's gone in the other direction, as ethicists worried during the Obama administration with his resort to drones in Afghanistan and Pakistan, autonomous weapons tend to lower the political costs of war to unacceptably low levels because you can inflict a great deal of damage on your adversary without putting your own people in harm's way. And finally, and this is where as an international lawyer I have a little bit of hope, we need to continue to build legal regimes and reinforce the regimes we have. The use of self-defense as a rubric to justify preemptive uses of force, whether it be by the Russians arguing for their invasion of Ukraine, or Israel attacking its neighbor states, or Iran, this is just a slippery slope that leads to bad results. IHL is an effective regime if it's used, as Cody suggested in his remarks on IHL reporting by states. I think we're also seeing the negotiation of new treaties, including the negotiation of a new Crimes Against Humanity Convention, which will in some ways fill the gaps in the laws of war. That's an exciting development. But even there, I need to caution that there are some democratic states that have argued that the lex specialis during wartime is actually IHL, which could potentially displace rules like genocide and crimes against humanity. I think that's just upside down wrong thinking, as the ICRC pointed out in its testimony to the Sixth Committee on October 14th of this year. In fact, genocide and crimes against humanity are peremptory norms of international law that do not get displaced during wartime. And finally, we need to support the International Criminal Court. It is true, as Cody said, that the ICC is not the only game in town, but right now we have several high-ranking ICC officials under U.S. sanctions, and it is deeply troubling to me to see that just at a time when U.S. uses of force and compliance with IHL are under global scrutiny, we have an attack on the institution that is charged by the international community, that's supported by 125 states, most small to mid-sized democracies, with enforcement of international humanitarian law, genocide, and crimes against humanity. So I think I'll stop there. I hope I haven't depressed everybody too much. But right now, I think we have a lot of dark clouds and a lot of really, really terrible conflicts, and we need to be pulling ourselves away from the brink, not doubling down on our right to misuse or abuse the laws of war. Thank you.
Thank you very much, Leila. For sure, the Geneva Academy lists over 110 ongoing armed conflicts on this very day. So we have several good questions in the Q&A, but I want to ask the panelists first if they want to take up any particular topic that has been mentioned by any of the other panelists. You can, of course, come back to it. Otherwise, we'll go to the questions. Omar.
No, I'm so glad Leila raised the point about the sanctions. And I just wanted to add to that because I think it really for all of us, I think I've raised this in a previous webinar, but I want to just reiterate it now that we've seen the expansion since we've last talked of who's sanctioned, of how damaging this is for the rule of law. More generally, my colleague published an op-ed in the New York Times with the head of Amnesty, kind of warning about the risks here, because what we're seeing, right, is even on the basis of the claim. So let me just state the facts first of all. We know the ICC several prosecutors and judges have been sanctioned, as have the UN Special Rapporteur for the Occupied Palestinian Territory, Francesca Albanese, as well as several prominent Palestinian human rights organizations. And the claims against them have been exactly about seeking justice at the International Criminal Court. And it's hard to overstate how crippling these sanctions are. There was I think a piece in The Guardian several days ago interviewing the leaders of one of the Palestinian human rights groups, laying it out. They're not able to pay their staff. They've had U.S. national staff for these human rights. I don't want to just focus on the human rights groups, but you know, you can imagine what it means for the prosecutors and judges and others. It means not having access to their bank accounts. It means not being able to engage with nationals of many countries. It's really upending that work. And if we set a precedent where a government which doesn't like certain investigations, I mean, we've seen Russia with its own legislation. I'm not a Russia expert, but we know Russia has its own legislation against the ICC. There's draft Knesset legislation that's also criminalizing cooperation with the ICC. So it's a really dangerous precedent. So regardless of what any lawyer in this call might think about a particular file or an arrest warrant, we should all defend these institutions. And it's a plea I've made in this forum before, because I think the ASIL and American lawyers in particular have a valuable voice here from just the perspective of defending the rule of law. So I'm glad Leila raised that, and I wanted to just state that now in case we don't get to it later.
Shiri, thank you, Omar. Shiri.
So I think my comment is kind of a continuation of the same point, because what I wanted to say is that I'm not convinced. So firstly, I do agree it's important to defend international organizations and tribunals like the ICC, and that this is one avenue for justice. However, I'm not convinced that individual criminal responsibility is what's going to bring justice in the near or even far future, especially as we see current violence being waged more and more by semi-autonomous, fully autonomous, weapon systems, including drones powered by, AI algorithms that promote different types of targeting, right? And so the cognitive part of humans in real-time decision-making, military decision-making, lethal decision-making processes is becoming narrower and narrower. And in my view, at least, many of the most horrendous crimes that we're currently, or let's just call it much of the violence we're currently seeing, is really hard to pin down or prevent in the future by finding the rotten apples and prosecuting them, whether in state courts or in international tribunals. So I think that alongside these vehicles, we should really put more attention into holding military or military organizations accountable in one way or another, in a way, at least kind of a future-looking way that would allow us to prevent the reoccurrence of these atrocities.
Thank you, Shiri. Leila.
Hi, and I don't want to get into too much of an ICC conversation. I don't disagree with Shiri that individual criminal accountability, it's not a talisman, right? It's not a quick fix to all of this, but it is an essential component, right? And it is actually in the Geneva Conventions itself that all the parties are required to search for individuals who have committed grave breaches, and we have a try or extradite requirement with respect to that. And the reason is that individual accountability matters just as collective accountability matters. So they're not mutually exclusive, right? What is disturbing, though, and to underscore Omar's point, and then I'm going to answer one of the questions that's in the chat about the Lex Specialis. To underscore Omar's point is Putin played the sanction game, right? I mean, Trump sanctioned in 2020, and he only sanctioned Fatou Bensouda and Fakiza Machoko, right? Two individuals that he wanted to sanction in that particular case. And that was over Afghanistan. And there, well, I didn't agree with it, and I thought it was completely wrongheaded and undermines the rule of law, et cetera, at least the stated argument was that there was a direct threat to U.S. national security because of the Afghanistan investigation. Now the sanctions are just coming out of the woodwork. They're really not related to any tangible threat to U.S. national security whatsoever. I mean, arguably the sanction against Kim Prost, who is the Canadian judge, a Canadian judge, by the way, who is a sanctions lawyer in Canada and one of the most distinguished international judges in the world, got sanctioned by the Trump administration allegedly for the Afghanistan situation. But in fact, the prosecutor immediately said, Karim Khan, that he was going to deprioritize any consideration of allegations against the United States. So in fact, what was really going on there, I think personally, was a sanction because Canada was going to recognize the state of Palestine. And I think you can also see that in the sanction against the French judge, right? Judge Guyot, distinguished member of the French bar, distinguished criminal lawyer. I mean, this is the United States acting like Putin's Russia. That's what Putin does. He's actually indicted some of the ICC judges because he doesn't like the arrest warrant against him. And so my gut feeling about all of this is the big problem with enforcement is double standards. We like the arrest warrant against Putin. We don't like the arrest warrant against Netanyahu, and so we sanction. And so that is just not a way to support the rule of law. And if you don't support the rule of law, because international law in particular is a reciprocal system, you unravel the entire system. And so it is really putting your alleged short-term interests, even if you could make those out, ahead of long-term stability, peace, and international justice. On the Lex Specialis point, yes, we have authority, which is the International Court of Justice itself. The International Court of Justice has said that in the Wall Advisory opinion, and again in the annexation opinion, and again in its other opinions, that IHL does not displace international human rights law. They coexist in many ways. And with respect to peremptory norms like genocide and crimes against humanity, which the International Law Commission has listed as peremptory norms of international law in its conclusions published in 2022, those norms cannot be displaced by other norms, right? By other lesser norms. And so that is just what a peremptory norm is. That's codified in the Vienna Convention on the Law of Treaties. That's in the jurisprudence of the International Court of Justice. We've seen this argument raised in the litigation between South Africa and Israel, where Israel sort of raised, well, like if we're doing everything legally under the laws of war, we can't possibly committing the crime of genocide. And that's just not how it works. You can't undercut the crime of genocide in that way. And so that is something we are starting to see a conversation about with respect to the crimes against humanity negotiations. Israel, United States, a handful of states raising this lex specialis. It's true, rules of detention, of course, you're going to apply IHL, but overall complicity in crimes against humanity or genocide, those are peremptory norms, and the ICJ, the International Law Commission, the entire corpus of international law tells us that peremptory norms of international law do not get displaced, even in times of armed conflict. And of course, Nuremberg is the original source for that, where crimes against humanity law emerges to fill that gap in the laws of war, because what the Nazis were doing with respect to the Holocaust was so horrific. And we just have to remember our 80-year Nuremberg origins as we negotiate and think about the law today. Thank you.
Thank you, Leila. I'm going to ask Pranav to pose a question that's specifically for Cody. from the Q&A.
Thank you, members of the panel, for your opening comments. This question is addressed to Cody. Cody talked about Ukraine's voluntary reports on international humanitarian law. Russia withdrew its acceptance of the competence of the Fact-Finding Commission under Article 90 of the Additional Protocol 1 to the 1949 Geneva Conventions. Over.
Thanks.
And so that's correct. So we see Russia. You're talking the Russian withdrawal of additional protocol 1. This is, I guess, what, October 2019 this occurred. And obviously I think that's one that's concerning. I'm not sure I'm not sure if it's actually a question, but a statement, and I think we should all be concerned that going back to what Leila said, is that there in some ways that a retreat from IHL obligations is a breakdown of the rule of law. And that's something that we should be certainly concerned about. And Russia's stated withdrawal from Additional Protocol 1 fits that bill and is very much a retreat from the rule of law and recognition of IHL specifically.
I'm going to jump in here, and since the ICC has been referenced, what about the fact that the United States is not a signatory to the Rome Statute? How does that impact, or how ought that to impact U.S. The U.S. view of ICC indictments, for example? Should it?
I'll just jump in. The U.S. has had a real Janist-faced opinion towards the ICC. And I think Leila referenced this, and it's true. Whenever there were, certainly a fact that whenever there were the arrest warrant for Vladimir Putin, the United States not only was supporting the ICC, but was providing evidence to the ICC to help with that investigation. Whenever we see, and I'm really just repeating Leila here, when we see Netanyahu, the arrest warrant for Netanyahu, the reaction is quite different. So I think the argument needs to be that the U.S. should support the ICC because the U.S. I think is stronger, and the ICC is stronger both with the U.S. support of the ICC rather than regardless of it should be a signatory. I think we all could agree with that. Maybe it's not now, but it should ascend to the Rome Statute. But the U.S. is stronger rather than being antagonistic to the ICC.
We have several excellent questions, but Leila and then Omar, and then we'll go back to the questions, Pranav.
I think I'll just wait for the questions, actually, because Cody sort of channeled what I would have said about the International Criminal Court. I can always come back to it later.
Omar?
I'll just be 30 seconds because again, Cody said what I would say. I want to make the point that it's also the very same principles, right? Like the idea of, because part of the argument was, well, if a official or a member of a non-signatory state is indicted, that's an issue. But again, Putin was being indicted for crimes committed in Ukraine. Russia is not a signatory. Netanyahu is being indicted for crimes committed in the occupied Palestinian territory. So it's not even just an inconsistency regarding files. It's the very same legal principle and the same people that support one place and not in the other. And I just wanted to underscore that point to show again, it's really just, Leila said it, there's nothing but outright double standards here. And I think the point we have to emphasize is that double standards undermines these very systems that protect civilians everywhere. So if you don't care about Israel-Palestine, but you care about Ukraine, you're undermining the system. If you care about Israel-Palestine, but you don't care about Ukraine, there's a consistency that's very lacking when it comes to the political will of states. And I think in general, what Gaza has shown us, or maybe the last 3 years, because Gaza and Ukraine happening at the same time, and the selectivity there is that, that I think the institutions like the ICC and ICJ have risen to the occasion, and Myanmar, whatever you find, that there have been strong rulings despite political pressure of the UN system, but member states, for the most part, have not.
Thank you, Omar. Pranav, do you want to start in on the questions? Thank you.
Yes. The next question is open to all panelists. What do you opine the effects of quote, US peace plan, unquote, adopted by the UN Security Council will be on the rule of international humanitarian law, especially on the use of force and determinations of the ICJ. Over.
I'll start. So I just want to start by reminding everyone of UN Security Council Resolution 242 that was unanimously adopted on the 22nd of November 1967. So this is the resolution that adopted, the two-state solution, created kind of a peace plan that was quite clear, at least on kind of the borders and a lot of other questions. And many, many decades later, still, of course, no implementation whatsoever, and the situation has been deteriorating ever since. So I'm not convinced at all that that this would make any significant difference. I do think that the Security Council resolutions, they have, legal power, and they are, setting some normative path. But when it comes to peace processes, not only in the Israeli-Palestinian context, but in others as well, ultimately, whether, peace is achieved in some way or another is typically up to the those who have a stake in that conflict. And I think international pressures can continue regardless of whatever pathway is adopted by the Security Council. So I think, like in other historical examples, I think ultimately peace can be achieved through many different ways, including a lot of organized and not organized international pressures that can come from a variety of sources.
Does anybody else wish to comment on that question?
Maybe just a
Okay.
one finger, which is that there's an interesting question inside the question. The International Court of Justice has just told us what the obligations of Israel are with respect to occupied territories in two advisory opinions, right? Two separate advisory opinions. And so I think inside the question is buried an idea of, could the Security Council change that? Right? Could somehow a Security Council resolution unwind the International Court of Justice? I personally don't think the Council has the ability to make law. So I don't think on legal standards the Council can do that, on what are the obligations of occupation, what are the obligations of IHL, is annexation lawful? The ICJ has said in Chagos, it said it in the advisory opinion last summer. No, it's not lawful. So that can't change. But the question is, can the Security Council play a little fast and loose with some of that by creating a new sort of transitional regime, which I understand is sort of implicit in this resolution? I think that's an interesting question of the power of the Council as a political organ of the United Nations. And that comes up periodically. Can the Council ever be seen as acting ultra vires, for example, outside of really its powers or constraints under international law? I think it depends on how this resolution is interpreted and how it's applied. But I think buried in the question is a very interesting sub-question of the power of the Council vis-a-vis the corpus of international law.
Thank you. Pranav, next question.
Thank you. This one is open to all panelists as well. In the current context, are we moving to a more diplomatic and political approach to the implementation of IHL? Or should we really hope for the revival of the legal framework on IHL? Over.
Did everybody, I know there was an echo, did everybody hear that question? Do you want it repeated? Okay.
I suppose I'll just, it's a two-word, which is that they go parallel. I think there's a legal application and there's a political application, and the political application should track the legal application. We do know that states will act in their self-interest, and that was my whole intervention, right? It's the point of the international lawyers to say, you know what, don't do that. That's not okay. It's not legal. And we're seeing exactly, I just have to add a one finger with the Venezuelan boat strikes. We're seeing exactly the same pattern we saw in the early 2000s, which is Justice Department lawyers without expertise in international law justifying military actions that don't comply with the laws of war, with rules on the use of force, and with international human rights law. And I think that the United States is making the same mistake 25 years later is just, it's depressing.
Omar, thank you, Leila.
Yeah, I just want to, say that I think it's worrying if that's the road that we're going on. I think that's probably not. I think in Israel-Palestine we've seen that for a long time, right? Where international law. When you have abuses of international humanitarian law, when you have human rights abuses, they should be resolved whether or not there is a ceasefire or peace deal. But invariably, whether it's from 1948 and the right of return to everything that's happened since, stop building settlements, go down the list, freedom of movement people in Gaza. It's always like, well, the peace process, will address it. And we see the problem with that because in Israel-Palestine, again, the area I work in, so to always come back to it, it's often seen as human rights abuses are the symptom. They're not the root cause. So if the root cause is the two sides can't sit on the table, that's not the root cause. The root cause is like anything else. It's an endemic structural system of repression that's in place. And so, and again, this is not just unique to Israeli abuses, by the way. I would say the very same thing when it comes to the PA. I've been in meetings in Paris pushing the PA to cut funding to the PA abusive security forces. And what I get back is we need the PA for the peace process, So invariably, and that's if you have well-intentioned. I don't know if folks have, right before this webinar, saw the comments President Trump made with MBS, and if not, you should see them praising how his human rights record. So if that goes to show you anything, it goes to show you that the minute you politicize and you let law and human rights, kind of be subsumed by politics and we've been talking about, it's been the theme of this session, right? Is you get the double standards. That is, Shiri makes a good point about international. I wanted to come back to the point of individual criminal responsibility. I tend to err more towards Leila's view, but more because I've seen it on the ground in Israel-Palestine be a deterrent. I've seen former senior Israeli officials say we didn't raise the Palestinian village of Khan al-Ahmar because we worried about an ICC arrest warrant. I've also seen the current Israeli foreign minister come back, and this is not specifically about accountability, but it's a sanction, come back from the EU and say, hey, the EU-Israel trade deal is at risk if we keep letting no aid into Gaza. This happened back in May. So I do think beyond the imperative of justice for victims, which I think we can lose sight of, which is important. And by the way, the ICC and justice more generally does provide hope to victims. I talk to victims every day, and the prospect of justice does provide them with hope. But I also think it is a deterrent. And so I don't think we should expect. I can't remember the term that was used by Leila, but we can't expect that everything will end the minute official X or Y is put in detention. But at the same time, you need some arbiter for the law that's not, and that's why the ICJ advisory opinions and the genocide case have been valuable because they've given us some marker there that can be used. That's not what a particular head of state thinks. Because again, the last thing I'll say is forget the U.S., France, right? When it came to its position on the ICC, the minute it wanted a ceasefire in Lebanon, it basically said, okay, we'll let Netanyahu fly over France because we need a ceasefire in Lebanon. That's a really clear example. I should say this is what's been reported in the press. I don't have any firsthand information, but that should tell you that the minute you politicize the law, the minute you create these kind of trade-offs, which, doesn't do us very good as an international law. People care about international law and universal norms.
Thank you, Omar. Shiri, let me know when you'd like to make final remarks. I know you have to leave.
Thanks. So I just wanted to qualify a little bit, kind of the minor disagreements on individual criminal responsibility, because I I'm not against, of course, the individual, criminal proceedings at the ICC or domestic courts. I'm fully supportive of the ICC, of any other international domestic tribunals that can justly and fairly prosecute war crimes and other relevant crimes. So I do think it's important. I completely agree with Omar that it does have at least, some sort of deterrent effect on those who participate in war, and I value that greatly. My comment was to say that deterrence effect, I think, is mitigated through the mediation of current and emerging military technologies, because those participates in those atrocities don't really think that it's their responsibility. They're a part of a big infrastructure of violence, and the link between their immediate actions or decisions to the actual horrendous violence on the ground is becoming more and more distanced. So my point was not to kind of discredit, the importance of individual based processes, but rather to say that it's probably not enough, and we do need to pay some attention to that sort of growing mass violence that is enacted through large-scale mechanisms, that very little of it is really kind of human controlled or can be attributed to individuals. And we see that. So for me, the main problem is, and it relates to the last question there on, whether there are any Israeli proceedings currently ongoing. It relates to the point that we see very, very few convictions in those in similar cases, because the direct link, or the individual responsibility of humans, even though we would like to say, even with the AI or with autonomous, semi-autonomous systems, there is always an individual who is responsible for the deployment, the mental element required for a conviction in most of these cases will simply not be proven, to the required burden of proof. And I think this is a real problem. And I think that actually holding individual criminal responsibility proceedings and then having, a lot of those being released because we simply cannot prove that sort of direct link between an individual and the outcome, right? I think it is a concern, and I do see that in a following a lot of horrific instances of violence, that we simply cannot identify the person who can be successfully, prosecuted for it. So that was the point, that I think we need to perhaps enhance those, or perhaps find some complementing processes.
Thank you. I think that Leila will address there's a question about Nigeria that Leila, I think, will address, and then we'll entertain the last three questions.
So, full disclosure, I used to be a member of the U.S. Commission on International Religious Freedom, so I'm very familiar with the CPC designation and the idea of a country of particular concern. I want to tie that designation in, and so maybe I'm not going to totally answer your question. Congress has proposed, I just pulled it up because I hadn't realized that Nigeria had been redesignated, and there is a resolution pending that would call for Magnitsky sanctions on Nigeria as a result of basically largely Islamist actions against Christians, which tends to be a usurped preoccupation, but also against minority Islamic groups. But I'd like to tie it back to our larger question about U.S. support for international institutions and IHL more generally, because Nigeria has been under preliminary examination at the International Criminal Court for a long time for exactly this kind of activity. And imagine a world, as Cody referenced, in which the United States had a judge at the ICC, the U.S. persons were working at the ICC. The ICC has been under-resourced. It's got 17 situations under its jurisdiction, 18 judges with a budget less than the fire brigade of Berlin, right? So it just doesn't have the resources. And so Karim Khan, basically the preliminary examination got closed with respect to Nigeria, but there was an actual conclusion that war crimes and crimes against humanity were being committed on the territory. country. And so I think the designation is totally appropriate, not just for religious freedom reasons, but for a whole lot of reasons. But it's important for states like the United States to work with international partners and with international organizations, actually trying to do good in the same spaces that the United States is concerned about, even if our concern is for different reasons, because many people, you know, the USERF concern is more about Christian persecution or persecution of religious minorities. Larger scale atrocities are being perpetrated there, and Nigeria, being one of the most powerful, richest, vibrant countries in Africa, like really getting that right is important. Right now they're looking at prosecutions as a possibility. Karim Khan is, I think, in dialogue with Nigerian authorities under complementarity, but that's just one where the US has missed a huge opportunity in an area in which the United States actually cares about, to work with international partners and allies to achieve, you know, mutually reinforcing goals. So I'll stop there.
Thank you, Leila. We're going to let Shiri offer some concluding remarks, then we'll come back to the other panelists with the last few questions and ask them to give their concluding remarks.
Thanks, Marianne. I can stay for, I think, 10 more minutes, so that's fine. But I'm happy to just use that opportunity to answer the next question, which is, has any soldier or official of Israel been prosecuted for killing or mistreating Palestinians? Because I do think it's a really important question and relates to the discussion that we've had here in the last couple of minutes. So yes, Israeli soldiers have been investigated and a few been prosecuted, but no one thus far has been convicted in any crime. Of course, those instances are very, very few, and the only one I can recall right now is the case of the horrific torture in Deakin detention facility, where that I referenced earlier in my notes. So, in that particular case, Israeli soldiers have been investigated and I think indicted for torturing and raping a Palestinian detainee in Deakin. And this is the case where it's the only case thus far that has been, people have been indicted because there was a leak of a video of the actual torture, right? But in what's happening in the last couple of weeks in Israel is that the chief military prosecutor has been arrested with charges for leaking that video, and with completely unsubstantiated claim that that video has been tampered with. So while throughout the last 2 years, she has been, protecting and shielding Israeli soldiers from indictments and from persecutions and from any kind of revelation about violations of international and domestic law. In that particular case, the horrendous type of violence against a detainee, caused her to release some of the investigation materials, because I think she thought, if that would come out, at least she would have some sort of social environment that would allow her to indict in that case. But as of now, the only case that has been, really kind of progressing is the case against the military prosecutor and the case against those who perpetrated the terrible violence and crimes against detainees. Seems to be crumbling. Of course, conveniently, the person, the Palestinian who has been the victim of this terrible violence, at least, probably many Palestinians have been victims of violence in this detention facility, but the video related to that was leaked related to a particular detainee, and he was conveniently released in the ceasefire agreement that Omar referenced before, along many other Palestinian detainees. Conveniently, of course, even though the investigation has been ongoing, no testimony has been collected from him in a way that could then be served as evidence in trial. And so at the moment, at least, it seems like this case would be would have some challenges, evidentiary challenges at least, that the defense, I'm sure, would use. So even though the answer is yes, there has been this one case, I'm not very hopeful for the outcome. And the only one who's currently under arrest is the military prosecutor. And I would just mention perhaps I think this links back to what Omar said before about the raging violence in the West Bank. A few months ago, a Palestinian human rights activist, Uda al-Hathalin, was killed with a direct shot by a Jewish settler. There is a video documenting the whole the murder, and which was completely, so Uda was just standing, far away, not being involved, was just, recording everything in his phone. That actually took the entire, so they're still recorded until he died. And even though everything is, well documented, there are many, many witnesses who saw this this murder as it unfolds. Still, an Israeli judge released the Israeli settler from any sort of detention, claiming that there is no causal link between the shooting and the death. So again, this is another sort of case that has been unfolding because of significant international attention and a full video recording of the entire incident from start to finish. Of the crime, I should say, not incident. And again, it doesn't seem like the Israeli justice system, or I should call it the legal system, would carry out justice in those very, very few cases.
Thank you, Shiri, for that comprehensive answer. I would draw everyone's attention to the fact that Leila has posted Resolution 2803, and it should be visible to everybody. Pranav, do you want to read us the last question? And there's one question left that Pranav's going to read. And then I think we're going to go in the same order we started with please answer the question if you choose to and offer your concluding remarks. We'll start with Shiri. Pranav?
Thank you. Was this Security Council resolution adopted under Chapter 7? As for ultra vires, the discussion takes us back to 1992 and the Lockerbie case. Will the ICJ be able to follow a different path? Over.
Shiri, you can answer the question or not, or you can just offer any concluding remark you wish to offer. Shiri, were you able to hear me?
Yes, I'm not sure that I have a good answer for this one. And I think since I just gave this very long speech, I'm happy to let others take this or another issue.
Thank you very much for all your insightful remarks. Great to see you. Omar, do you want to go ahead and take a crack at it or offer conclusion?
I might pass it to Leila because I feel I saw her body language suggests she has a better answer than I will. So I could have misread my screen. But what I do want to say is just maybe, I mean, I feel like our comments have all been concluding remarks, so I'm not going to repeat the thing I said earlier. But I will say, I mean, I noted earlier like learning from history, and I focused on Oslo and the risk of the ceasefire agreement. But actually, I kind of want to go back even further because many have described the hostilities, what we saw the last 2 years is unprecedented. It is in many ways unprecedented in the modern history of Israel-Palestine, and in some respects, maybe more beyond. And I think we should look back to the lessons of what happened in 1967 and 1948 and avoid repeating those mistakes. And part of what we learned in those times is, despite the words on paper, first thing we learned is you should always prioritize the return of refugees. And I think that's a really important point. And people are kind of forgetting there are 100,000 people outside of Gaza today, and they're not able to return. I think it's really important to note there are 32,000 people within the West Bank that are not being allowed to return. Within Gaza, there are people who live in the 52% that Israel controls and is demolishing. They're not being allowed to return. There are people that are returning to nothing, right? To rubble folks may have seen the news reporting about this, mysterious plane that showed up in South Africa last week, and we could talk. There's a lot of interesting law underbelly there, which it's another long answer, which I won't do in my concluding remarks. But what I do want to say is that the real important point to sort of underscore here is if people don't have schools and hospitals and water and electricity, they may not leave today, but they'll leave in 3 months and 6 months and 9 months and 2 years. And, if you have an 8-year-old, a 12-year-old, a 74-year-old that needs, what are you going to do, right? And so that's why the principle of return and free movement is so essential. And so I really do think, again, as lawyers, it's worth us looking back not just at recent history, but that history. And part of what we learned there is also words on paper. I mean, we've been citing UN resolutions. There's also the resolutions, again, about the refugee return that were ignored. The Trump plan says people in Gaza can leave and can return, but when Israel's not following the letter of the law when it comes to aid trucks, which are so quantifiable, right? There's a number, right? And it's not being met. How can we expect other things to follow there? Which is, again, why we need concerted action from states. So, yeah, I guess my lesson is, let's use history as a cautionary tale, because we're following into the very same patterns, but with a much worse reality on the ground, where any non-action, freezing the status quo in Gaza today after 2 years of methodic destruction and razing and killing and healthcare and no food, means thousands more will die. I mean, I'm not speculating, right? This is just a fact that we have said, and medical experts have said as well. So we need action urgently. We can't turn our eyes away because there's an agreement that puts Gaza and Israel-Palestine on the news every day.
Thank you very much, Omar. Cody.
Thank you, Marianne. I also am going to let Leila answer the final question involving the Security Council resolution and Chapter 7. But I will provide some concluding remarks. And I started by noting that IHL still matters, and that's important to think about, right? IHL matters and international law matters. And if it didn't matter, nations wouldn't contort what they say when they violate IHL to seem to act like they do. But it's also important for all of us to hold people to violations of IHL. And I think we see this in the United States with the drone strikes in the Caribbean and the Pacific. And Leila mentioned it earlier, but the IHL argument that somehow the Latin cartels or drug cartels are designated foreign terrorist organizations, that somehow converts this into a non-international armed conflict, is frankly wrong. And it's important to acknowledge that and to hold people to account when they are improperly making IHL arguments. At the end of the day, we talk about the importance of the rule of law, and the rule of law is built on trust and cooperation and compliance. And we need to, I hope that as we think about the future of our world and abiding by the rule of law, that we can all return to those critical pillars that will most of all make the world safer. And then when we think about IHL specifically, the pinnacle of IHL is protecting civilians, and that it will get back to that critical component of IHL. So with that, I turned over to Leila.
Thank you, Cody. Leila.
Thank you. Well, Resolution 2803 is mysterious because unlike many other Security Council resolutions, really all the other Security Council resolutions that are adopted in this space, it doesn't make reference to some of the earlier resolutions, like it doesn't invoke 242. It doesn't invoke really a firm right of the two-state solution, Palestinian self-determination, etc. So I think what I'm reading in Past Blue, and I want to go back and actually watch the transcript and watch the adoption. Russia and China abstained. It was 13 to 2 abstentions. They could have vetoed. I get the feeling a lot of states voted for this sort of holding their noses because there were a lot of contemporaneous statements. It's not a Chapter 7 resolution, and it doesn't invoke all the earlier resolutions. It's a very, very odd duck. It's not yet publicly available on the UN website, but you can find, I found a text of it on Middle East Eye and some others that have analyzed it. So I think the resolution is people feeling, and this goes to maybe my final remarks, is that when you have a state that decides for whatever reason it's feeling threatened, its people are threatened, whether it's Russia's invasions of Ukraine, whether it's what's happening in Darfur, whether it's what happened in Tigray, the DRC, or in Gaza. And when you have leaders that decide that they are going to engage in tactics that we would say are inconsistent with international humanitarian law and the rules of international law, nobody's going to come and save the people that are on the receiving end of that treatment. And that was something that the Syrians learned. There's a wonderful book on Syria that I read, Voices from the Syrian Civil War, where they really thought at one point maybe the United States was going to save them. They'd have this no-fly zone that would be put into place, and the use of barrel bombs and chemical weapons and all sorts of atrocities committed against civilians would stop. And in fact, there was no white knight riding in on the cavalry, right? There was no cavalry that came to save the people of Syria, 500,000 of whom, died in that war. And what's happening in Palestine is basically the same thing, which is that you have a situation on the ground that's horrific. As I said, it looks like District 12 of the Hunger Games right now. Gaza is uninhabitable. The Lancet just published a study that talks about 3 million lives lost, that is years of life lost by the people who are there. And nobody's coming to save anybody, right? There's no white knight. We don't have people from outer space that are going to come and save that civilian population. And so I think people voted for that resolution because they really did hope that if the United States was willing to back it, that the Israelis would stop the bombing and that there could be some kind of reconstruction, whether that will be reconstruction along the lines that is hoped for is an open question. In terms of Lockerbie, 1992 is really different than 2025. The International Court of Justice has become a very, very different court. When I teach international law, I used to teach the 2 S's and say it's sovereignty and stability. That's what the ICJ cares about. And now we've seen that the International Court of Justice really cares about self-determination. We saw that in the Chagos opinion. We've seen that in the advisory opinions. The climate change opinion is a blockbuster from this past summer. And so this court that I think was much more conservative in prior years has become much more understanding and sensitive to human rights concerns and concerns about what the planet needs. So whether we would get the 1992 Lockerbie decision again, I don't think so, but I think it's a very open question. If I'm going to conclude with anything, I would just like to evoke the memory of the victims. The victims in these conflicts are the women, are the children, are the soldiers, are the individuals either sent to fight, forced to fight, evicted from their homes, traumatized by war. And I think that we have to keep in mind that our job as international lawyers is to promote the humanity and the civilizing purpose of international law and these norms. And right now they're not being respected by many states around the globe. And our job, it's a small job, but we do what we can as international lawyers, is to say that law really does matter, and to try to convince leaders and politicians that it's in their enlightened self-interest and that it's the right thing to do to comply with the norms of international law. So I think I'll stop there, Marianne, and thank you so much for the opportunity to be here, especially with such smart, wonderful co-panelists.
Thank you very much, Leila. And thanks to Shiri Krebs, Cody Corliss, Omar Shakir, and Leila Sadat, our wonderful panelists. That was a terrific discussion of very important topics and wonderful way to conclude, Leila. I'd also like to thank Pranav Agarwal for moderating our Q&A for us. Thank you very much, Pranav. And I'd especially like to thank Britta Jella, Taylor Kilpatrick, and Jim Steiner of ASIL, who have so ably helped us. I wanted to let you know that there will be another in the series, hopefully in early 2026, so look for that announcement. And great questions from the audience.